The central issue is whether Mrs. Lim can bring her 20,000 ringgit claim for a faulty washing machine before the TTPM, or whether she must instead go to the ordinary civil courts. This depends on whether she is a consumer under Section 3 CPA 1999, or does the washing machine qualifies as good under the Act, or whether she can claim within the monetary limit and time limit in Section 98, and whether her dispute is not excluded by the limitations in Section 99. First, the legal framework. Under Section 85 CPA 1999, the Tribunal for Consumer Claims TTPM is established as a statutory tribunal under Part 12 of the Act. A tribunal is generally a body created by legislation to decide disputes in a specific area with procedures that are less formal, quicker, and cheaper than the ordinary courts, and designed to promote openness, fairness, and impartiality, as highlighted by the Frank Committee's conception of tribunals. This framework underpins TTPM's role as an accessible, specialized forum for consumer disputes, separate from the normal court system. Next, the core jurisdiction comes from Section 98 CPA 1999. The tribunal may hear a claim for redress arising from the purchase of goods or services within the ambit of the Act. Three key limits apply. The first one is it must be a consumer claim relating to goods or services covered by the Act. The second one is the amount in dispute must not exceed 15,000 ringgit, which is the current monetary limit following amendments. And the third one is the cause of action must have accrued within 3 years from the date the claim is filed. Thus, TTPM's jurisdiction covers consumers involving goods or services up to 50,000 ringgit and within a 3-year time frame. The definition in Section 3 CPA 1999 are crucial. A consumer is a person who acquires or uses goods or services of a kind ordinarily acquired for personal, domestic, or household purposes and not for the purpose of trade, manufacture, or repair. Goods are similarly defined as items purchased, used, or consumed for personal, domestic, or household purposes, which clearly includes household appliances such as washing machine. This definition ensures that disputes over ordinary household purchases falls within the scope of the CPA 1999 and therefore can potentially be brought before TTPM. However, the tribunal's powers are not unlimited. Section 99 CPA 1999 lists matters excluded from TTPM's jurisdiction, such as the first one, disputes relating to land, wills, or succession. The second one is claims for personal injury or death. And the third one is that matters that have already been determined by a court or another tribunal. Academic and practice sources stress that subject to these exclusions, any claim that first falls within the definitions of consumer and goods or services, is within the 15,000 ringgit monetary limit and is filed within 3 years may be brought before TTPM as of right. This aligns with the tribunal theory, which is Parliament intended small, specialized consumer disputes to be channeled into a tribunal that is autonomous, less formal, and more accessible than the ordinary courts, but still operating on legal principles and statutory guarantees under the CPA 1999.
The first case is So Tiang-Ju versus Tribunal for Consumer Claims and another. So Tiang-Ju bought a Mercedes-Benz E300 under hire purchase. After some time, the car developed defects in the blower fan and batteries, which cost over 5,600 ringgit to repair. Although the authorized dealer carried out the repairs, the manufacturer refused to reimburse him, saying the warranty had expired. Later, the manufacturer extended the warranty to 4 years, but only for cars purchased or registered after the 1st October 2011, and So Tiang-Ju's car had been brought 10 months earlier. Later, he filed claims at the Consumer Claims Tribunal against both the dealer and the manufacturer. Part of his claim was initially dismissed, so he applied for judicial review at the High Court. The court ordered the tribunal to rehear part of the claim, but the tribunal later again dismissed the claim regarding the blower fan. He then filed a second judicial review, which was also dismissed as well. Ultimately, the Court of Appeal later upheld the tribunal's decision, confirming that So Tiang-Ju was a consumer under the Consumer Protection Act and that the tribunal had properly exercised its authority. So this case had revolved around issues of high-value product defects shortly after purchase, as well as a warranty dispute. The second case goes to FA Wagon Sendirian Berhad versus Porota Corporation Sendirian Berhad. Porota Corporation purchased a brand new Volkswagen Polo sedan 1.6 vehicle. So within a month, the car began showing multiple defects, which include problems with the gearbox, engine mounting, brake disc, battery, and even the air conditioning. Over the next 4 months, the car had to be returned to the service center 8 to 10 times. During this time, the plaintiff rented another car at 200 ringgit per day. Eventually, the car was properly repaired after replacing the gearbox and engine mounting. After that, the Sessions Court held that a brand new car must meet standards of acceptable quality and fitness for purpose, which later upheld by the High Court. So this case shows that the impact of frequent defects shortly after purchase and the significant inconvenience to the consumer, which is very similar to the situation of a defective household appliance as well.
A
apply the law to the first for issue 1, for Mrs. Lim, it's quite clear she is consumer under Section 3 of the Customer Protection Act 1999 because she bought the washing machine from a retailer for normal household use, not for any business purpose. The washing machine is also goods, ordinary bought for personal use, domestic use, similarly to the cars in Soo Tiang Joo and F.A. Wickham cases where the cost treated those buyers as consumers under the Act. Here, the machine started leaking and having electrical problems just 2 months after she bought the machine, even though it was still under the warranty. That kind of early and serious defect suggests the machine is not of acceptable quality and not reasonably durable or safe, so the implied warranty in Section 32 and Section 33 CPA 1999 are likely breached, just like in every case where repeated defects in a new car will help to breach the guarantee of acceptable quality and fitness for purpose. Her claim is 20,000 ringgit, which is well below the tribunal's monetary limit of 50,000 ringgit in Section 98, and the problem arose well within the 3-year time limit. The dispute is only about defective goods and refusal to repair, replace, or refund, so it doesn't fall into any of the excluded categories under Section 99, such as lead or personal injury. In Soo Tiang Joo case, the Court of Appeal confirmed that once dispute falls within the CPA, the tribunal can interpret the warranty assessed evidence and either allow or dismiss the claim, and its decision is final and binding subject only to the review. So, apply the same idea, Mrs. Lim's 20,000 ringgit claim clearly fits within the tribunal jurisdiction, and TTPM is the right place for her to seek repair, replacement, refund, or damages.
Therefore, Mrs. Lim's 20,000 ringgit claim for the faulty washing machine clearly falls within the jurisdiction of the Malaysia Consumer Claims Tribunal under Section 98 of the Consumer Protection Act 1999.
The second issue is whether Mr. Ahmad's claim of RM 40,000 ringgit against a contractor for incomplete renovation work can be heard by the TTPM or must be pursued in court. The law that applies to this case is that the jurisdiction of the Tribunal Tuntutan Pengguna Malaysia (TTPM) is governed by Part 12 of the Consumer Protection Act 1999, CPA 1999. Section 85 establishes the tribunal and Section 3 defines the tribunal and confirms its legal authority. Jurisdiction depends on whether the claimant is a consumer and whether the dispute involves services under this Act. Under Section 3 of CPA 1999, a consumer is a person who acquires services for personal, domestic, or household purposes and not for business, trade, resale, or commercial use. The term services includes renovation, repair, and maintaining works performed in trade for private residential properties. Under Section 98, Subsection 1 CPA, the tribunal has jurisdiction to hear consumer claims arising from goods or services where the total claim does not exceed RM 50,000 ringgit. Under Section 98, Subsection 3, the claim must be filed within 3 years from the date the cause of action arose. If a claim exceeds 50,000 ringgit, Section 101 allows the claimant to abandon the excess so the claim can fall within the tribunal's monetary limit. In certain cases, Section 100 allows the tribunal's jurisdiction to be extended by written agreement between the parties subject to the Act. Procedurally, Section 97 requires claims to be filed in the prescribed form, and Section 116 provides that the tribunal's award is final, binding, and enforceable as an order of a magistrate's court.
On 25th July 2034, the Labuan Consumer Claims Tribunal ordered a contractor to refund 50,000 ringgit after failing to complete a house by 7th October 2033. So this delay caused the customer to incur additional costs to finish the work, which the contractor had promised but did not cover. The tribunal required full payment within 14 days and had highlighted its role as an accessible forum for claims under 50,000 ringgit. Next, in Johor, the Consumer Claims Tribunal in Johor dealt with the contractor who left a renovation 78% incomplete despite payments of 87,000 ringgit. So the contractor requested to repay the outstanding 17,695 ringgit and 7 cents in monthly installments over 3 years, but the tribunal rejected this request and ordered full payment within 2 weeks. So this delay forced the claimant to rent alternative accommodation and hired another contractor and surveyor. So the tribunal president, Hafiz Zakabli, emphasized that the legitimacy of the claim and ensured a prompt payment, which the claimant welcomed as it awarded a prolonged repayment plan.
Apply to the law of the case of the question in issue 2 for Mr. Ahmad. The key is whether his renovation problem is a consumer services issue under the Customer Protection Act. If the renovation was done for his own home, for his and his family use, then he fits the Section 3 definition of consumer, and the contractor is a supplier providing service in trade. That's the same idea we see in recent tribunal practice, where owners bring claims against the contractors for unfinished or badly done renovation and house building work. His claim is 40,000 ringgit, so it is well within the tribunal's 50,000 ringgit limit in Section 88, and as long as he files within the 3 years from when the contractor breached the agreement, the time limit is satisfied. This is similar to the Labuan case that have been mentioned, where the tribunal ordered a contractor refund 50,000 ringgit for failing to complete the house on time, and also the Johor case, where the tribunal ordered a contractor to pay 17,695 ringgit for leaving a terrace house renovation only 78% complete. Both clearly treated as consumer innovation disputes within TTPM's power. There is also an indication that Mr. Ahmad's situation involves one of the Section 99 exclusions like dispute of filling title, rulings in succession, or personal injury. It is simply about incompletion of renovation work and the loss is suffered. Just like in the Labuan and Johor cases, in this example, the tribunal did not treat the claim as a land dispute, but as a services dispute and ordered lump sum payment rather than allowing contractors to drag things out of long installment plans, showing that TTPM is prepared to give practical redress to companies. However, if Mr. Ahmad's renovation for commercial or investment property, such for example the shop lot or house renovation mainly for business or rental purposes, he would not longer fall under the personal, domestic and household limit in Section 3, and the tribunal's consumer jurisdiction would not apply in that situation. Even though the amount is 40,000 ringgit, he would have to sue in the civil courts, probably in the session court. But if the renovation is for his own home, like in the Labuan and Johor cases, then his 40,000 ringgit claim can probably be heard by the TTPM or tribunal instead of going through full.
Therefore, the conclusion in this case is that Mr. Ahmad's RM 40,000 ringgit claim for incomplete renovation work falls within the jurisdiction of the Tribunal for Consumer Claims. If instead it concerns a commercial or business property, the claim must be pursued in the civil courts.